Is serious. 4 blocks from the steel mill blast, I paint my claim upon the wall. 4 blocks from the steel mill blast, I paint my claim. My edge of the south side drags a common thought to call the cops. Further west it's been gentrified. They turned biker bars into flower shops. I kinda miss those Harley guys who rarely did a body harm. Mostly like to drink and shout, flash the pictures on their arms. Oh, 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 oh. Happens when the money comes, the wild and poor get pushed aside. Happens when the money comes, the poor get pushed. Buyers come from somewhere else, raise the rent so you can't hide. Buyers come from out of state and they raise the rent. Buy low, sell high, you get rich and you still die. Money talks and people jump, ask how high, low life. Donald, what's his name? Who cares? I don't want to know what his lover doesn't wear. It's a shame people at work want to hear about this kind of jerk. Oh, 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 oh. Where the bottles break by the playground fence, neighbors yell, they raise my rent. Thanks. All right, I'm gonna play one more tune, a song I wrote called Green Nearby. A little more cheery than the last one. Gray skies over me, but there's all this jade blowing in the breeze, so I am alright. All this green nearby, I am alright. All this green nearby. Got no cash to hold me over, so I set my eyes on this 4-leaf clover. I'll be alright. All this green nearby. Ooh, alright. All this green nearby. Fortune or fame, no, you cannot buy a happy heart. The green that grows beneath the soil of red, earth that gave us all our stars. Da da da, ooh, ooh, we'll be alright. All this green nearby, ooh, alright. All this green nearby. Thanks. Thanks very much.
I know we had just a very short break, but since we're a little behind schedule, I want to go ahead and get started. And so now we have Michael Rossoff, who is an attorney for landlords, and he's going to talk about some of the issues that arise from the landlord's perspective.
Thank you. First of all, I want to stress that a request for a reasonable accommodation affects time, space, and people, and it affects these three things in bigger ways than most people usually think. Because in terms of time, the responsibility for a landlord to start reasonably accommodating begins at the time that the tenant is first being evaluated for the tenancy. It's not something that just arises after a tenant moves in, but it actually happens before a lease is signed. It also affects space more than we normally think, because it affects just not the apartment the tenant moves into, but it also affects the use of the common areas, and it also affects the possibility of other vacant units in the building that might be offered to the tenant in an accommodation. So landlord has a lot of work to do when it comes to rolling up their sleeves and getting to work on a reasonable accommodation. And it also affects a broader category of people than we normally think of just the landlord. The landlord is not just the owner of the property. The landlord can be anyone who engages in the business of renting housing accommodations under this case of Swan v. Burkett, a 1962 case, 209 Calap 2nd, 685. Our local rent ordinance, Administrative Code Section 37.2H, includes sublessors as the landlords. If you are a tenant of an apartment and you go on vacation for 3 months and rent through Airbnb, you're a landlord, and you can be held responsible for these laws the same way the owner of the property might have been. So it's important to note that these laws apply in more ways than we normally take them to be. The penalties to a landlord can also be huge if they fail to comply with these rules. I know I'm here with my landlord hat on, but the best help I can give to landlords is to let them know that penalties for not obeying these laws can be up to $1 million. That's extreme, that's a very high amount, and those are in cases where there's maliciousness involved. But still, landlords must take these cases seriously. So when does this duty arise? It arises upon the time that the tenant is being evaluated for an application. But even there we have time, it's a very gray area as to when that happens. Many times tenants think that as soon as they show up for an apartment, say by crashing the gate and getting there 10 minutes early, that they're the first to come, that they're the first to be served. But landlords are advised to have written policies that they apply to each time they rent out their apartments. So their policy may be that they give first preference to the first person who contacts them, which could be somebody that was referred to them by another tenant in the building or by a neighbor. And if it's their policy to take the first contact and then evaluate, then that's their duty to do so. So let's take, for example, the landlord is evaluating the first applicant. He shouldn't evaluate anyone else. He or she should stay concentrated on that one applicant first. And if he or she finds that the applicant has had a history of being evicted for nuisance or for non-payment of rent, the tenant should be contacted and say, I'm sorry, I might not be able to rent to you because you have this history of not paying your rent or being a disturbance to others. And those are legal justifications I have, at least initially, to deny you. Do you have anything you would like to present to me at this time in mitigation for your bad apparent tenant history? At that time, the tenant can say, I have a disability that caused me to be noisy, to hoard and clutter, or to make disturbances in the middle of the night, but I'm now being treated. The landlord can then say, can you provide me evidence of your disability and substantiation that you're no longer going to be a problem should I rent to you? The smart tenant applicant then should supply that information from the doctor and allow the prospective landlord to contact the physician or psychotherapist or clinician to show that the applicant is a safe bet to rent to, that despite the prior history, the landlord should rent. And if with that evidence, the landlord, under these rules, should rent to that tenant despite the prior history. It's another reason to start evaluating the first applicant first and not start trying to do them all at the same time. Because the landlord can also get into trouble with having two equally qualified tenants with disabilities. And you're going to get in trouble no matter which one you pick. Or you may have somebody who needs housing desperately because of a domestic violence situation. And you don't want to get caught on the horns of a dilemma. So go individually, even though you might be under time pressure to rent that apartment. You need to spend the time to properly evaluate these requests for accommodation. So as a tenant, don't think just because you're the first one to show up at that open house that you're going to be given the apartment. If that were the case, then everybody would come an hour early. This evaluating the legitimacy and the applicability of a request for accommodation often goes by the acronym of a dance. And that probably arose because one of the earlier cases years ago, the judge called it a tango. But it does involve at least two different, it involves at least two different parties. And as some of the speakers earlier today stated, it often can involve cadres of people who come to do a fair evaluation to see what can be done with specific disabilities. For example, for animals, at the initial application, do note that animals can include mammals, reptiles, or birds. There are differences between support animals and emotional support animals and service animals that can come into play. Administrative judges have ruled from HUD in favor of emotional support animals despite their lack of training as being reasonable accommodations. Several courts have also ruled that untrained assistant animals are reasonable accommodations. Yet there are cases that have held that an assistant animal, in order to be considered a reasonable accommodation, must be trained. So whether the animal should be trained or not as an emotional support animal is probably a result of each case. So again, the importance of spending the time necessary to work with the medical professionals representing the tenant to determine what is the best thing to do regarding pets. For mobility issues, right from the get-go, the landlord should decide whether it's a reasonable cost to put in a ramp, the cost of sidebars, or provide another accessible unit in the building, maybe another place has come available on the first floor where somebody in a wheelchair can just roll right in. And also, whether parking is available and needed, and if so, then that should be provided to the applicant also. I've already talked about what might happen if the tenant had a history of disruptive noise and behavioral issues. In shorthand, if the applicant is alcoholic or has other problems that cause them to make that noise, if that person is not in treatment, the landlord would have a good justification for denying the application and going on to the next applicant. But if the tenant with medical evidence shows that the applicant is in treatment and is is not likely to cause further problems, then again, the lease should be signed with that applicant. If a tenant has a history of hoarding, the tenant could covenant, I suggest the tenant can covenant in the lease to provide their caregivers and support services to keep the unit clean and safe, and then agree to be evicted should the unit become a problem. And by a problem, I don't mean whether it just becomes a little cluttered. I mean, and what the courts generally look at is whether the hoarding gets to the point where it's a health and safety issue. If other tenants are complaining about smells coming from the unit, whether there's vermin like roaches and bed bugs and so forth that are coming out. At that point, the tenant is in clear breach and should be evicted, either as a nuisance or for the breach of the lease that they signed, that lease again being amended to accommodate. That same kind of accommodation should be written into the lease from the get-go when there's a pet. If it's advertised as a no pet building, the landlord is not allowed to hide behind his advertisement. Even though it says no pets and the lease says no pets, as a reasonable accommodation, the landlord should cross that part of the lease out and say one service animal permitted by the name of Lulu, and as long as Lulu isn't a Lulu, and then make an accommodation later on after the tenancy commences, because if Lulu has a litter, the landlord has a duty to accommodate that too, and allow the mom to take care of the little ones until they can be given away, and then come back to the original lease provision allowing for only one animal. But give a reasonable time for the right thing to be done. It's when landlords come to me and demand that somebody be evicted because their service animal had a litter, I have to send that landlord away. There are basic understandings of the way that we comport ourselves under these laws in California, and we're not allowed to evict for soft cause problems like a litter, for putting your laundry out, so it can air dry without the use of chemicals if you're chemically sensitive. We need to accommodate tenants that have those specific needs. And in fact, Supervisor Kim is now promulgating legislation in San Francisco that's right on the mayor's desk today. So, and we don't know whether he's going to sign off or not. That will specifically prohibit these soft cause evictions.
Excuse me.
Yes.
Can I ask a question? Do you mind?
Of course.
Just going back a little bit, and it's a quick question. When you were talking about landlord's duty to go by the list, the first applicant, and look through the first applicant's qualifications prior to going to the next, even if the next person has a reasonable accommodation. Does a landlord have a responsibility legally to prove to, let's say, an applicant that there is actually other tenants in front of them? I sometimes deal with people, not where I'm currently at, but people who believe that that's just what the landlord is saying because they don't want to necessarily have to deal with their reasonable accommodation, or they feel a certain way. And I know you're here with your landlord hat.
Yeah, right here.
Sorry, but I'm here with my tenants' rights.
Absolutely. And we can find common ground on that. There's a lot of it, especially in San Francisco. But let me answer this question first, because it's an important one.
Thank you.
That's another reason why landlords should have strict rules that they go by and they use in every circumstance. And if those rules are followed, the applicant or the person that came later and is not under consideration at that point, and they really have no standing to inquire. So they would only have standing to inquire and ask, well, why not me? Why didn't you evaluate my situation? If they stepped into litigation, or and that's a chancy kind of thing to do that possibly Tom Drohan can advise you on. And I'm sorry, ma'am, you had a question?
Actually, mine was to do with reasonable accommodations, basically. Can't hear you.
It all depends. As we're saying, each case is different. But if you're physically disabled and you need a caregiver, if I, for instance, were a tenant and I had a stroke tonight, and tomorrow morning I was no longer able to cook for myself or clean for myself, I could make a reasonable accommodation as a tenant and be expected, particularly under this new ordinance, to have the lease changed or amended to allow a full-time caregiver to come in and do all of those sorts of things for me. So the answer, and under most circumstances, is yes. And even if your lease says that occupancy is limited to only one person, and naming you, it can be fairly amended, particularly under this new law that will probably allow people in a studio to have 2 people living there, and a 1-bedroom to have at least 3 people. So the answer, in most circumstances, under a qualified disability, would be yes. And one more, and then I'll have to get.
My question is, you said something about accommodation, and if a person had a wheelchair now and they needed to move to the first floor, is that something that, if a unit becomes available, that is the law, or that's a reasonable landlord would do that?
There's no law specifically stating that. Under the rent ordinance, if that were to happen, the landlord would arguably have a right to raise the rent to market rental rate. But I would advise most landlords who were graced with more than one unit to rent, if one came available for a tenant who needed it, who could no longer climb stairs, I would urge them to rent the apartment downstairs and reach an accommodation as to what the rent might be. And the rent board is a good mediation, free mediation service for that kind of thing. There's no law per se. Tom, do you know of any?
Well, I would say it's a reasonable accommodation of the disability if the request had been put in when there was the open unit, that they would have to be moved. And failure to move would be a denial of the request.
That's correct, but I think the question is there any black letter law right now that says so, and I'm not aware of any. You bet. Okay.
I just have a quick question, and for either one of you, something that you said, Michael. As in employment law or other fields, housing in this case, a tenant or an applicant for an apartment does not have a duty to disclose, and I would think most applicants would be well advised not to disclose. In other words, get the apartment, get their foot in the door, whether it's a job, whether it's an apartment. The only time they have a duty to disclose a disability is when requesting a reasonable accommodation.
That's true.
And even then, there is no letter requirement unless, as we're talking about, it's an invisible disability and they're in the good faith interactive discussion period. So, Michael, when you said when someone's applying, they may be better off stating that they have a disability, however, it's not really going to be a problem. I guess there are 2 ways to look at that.
Well, let me, Mr. Bruce, the reason I said that upon the application is only under the circumstances when the landlord has checked the county records and found out that you had been evicted 3 times before for being a nuisance.
Oh,
then I would, yeah, that's a very important part of the landlord procedures that I'm here to tell you about. So as a note of hope, so if you have or know of people who've been evicted before because they didn't get their alcohol under control or their medication wasn't right, and then they're out again competing with everybody trying to find a home, it's not hopeless, because if they are denied, they can then raise and make a request for accommodation, and the landlord must then, before they're denied again, they have a right to a fair and just accommodation, as long as they can prove as the next step. Yes. Not just necessarily proactive, but involving themselves in the dance at that point, and showing the landlord that they're a safe bet to be a tenant, and to get their record clean and get a fresh start. So it's a little known kind of procedure. I'm not going to call it a trick. I'm going to call it a procedure. So tenants don't have to pretend or conceal their disability and then sign a lease, which is something they might not even be able to do if their prior history became apparent. And with the record keeping the way it is nowadays, most landlords know about tenants' past histories. Their evictions, tenants' evictions might be sealed at the courthouse, but when that happens, there's a blank screen that comes up under the name when you call up the name, and that's a tip-off to most landlords that there's been an eviction.
So that may be the tenant's exercise, prospective tenant's exercise of judgment, to disclose or not disclose. If the landlord is probably going to find out anyway, I don't think it's good to use alcohol as an example because there is a special rule for that. Anyone with a history of addiction is a disabled person. Anyone who's actively addicted to alcohol or drugs are not protected under the fair housing laws, state or federal. So that is.
I understood that they were if they're under treatment.
They argue in court about how many months or how much treatment is enough so that they have a history of, but they're not presently actively involved. That works both ways, but certainly if someone, I'm asked to speak into the mic, thanks. If someone, and this is in all areas of law, not just housing, if someone has a history of addiction to drugs and or alcohol, but is not actively addicted, as in currently drinking on binges or taking illegal drugs, they are protected. In other words, it is a disability to have a history of alcohol and or drug addiction. Current involvement in an active addiction means you are not protected. So I just want to mention that because you can't just lump that in with everything else, and that's been the case since 1990 with the ADA, where Congress spelled that out, history of versus active current addiction. So whether or not the landlord wishes to disclose something like that, he or she may be well advised to be aware that one is a protected disability under the anti-discrimination laws, history of, and the other one is not protected. So it's just something that comes up, and they do argue over whether it's active or not. If it's been, the question is, well, how long? Is it 60 days, 6 months, 1 year, or 2 years before there's an agreement? And they fight over that in court, is what happens in those situations.
Speaking of which, upon the termination of a tenancy, these issues can arise again. Again, the right for a tenant to assert a reasonable accommodation goes up to and including the last day of their occupancy. So if they're there waiting for the sheriff to evict them, they can raise a request for accommodation at that time. And our local sheriff's department will often accommodate. The landlord technically is responsible for accommodating too, particularly for a new disability that might have arisen. But how does a landlord get to the courthouse with a bona fide eviction case for a tenant for a disabled tenant who's been causing a nuisance? The best way to do that is to prove his case. 95% of the work is done before any eviction notice is served. I recommend as many warning notices to be made and served on the tenant, specifically stating what those nuisances are. If the tenant invites a collaborative effort with caregivers, or with the medical world, the landlord should jump right in and do what they can to accommodate, and have that be an ongoing process. And that's when the dance gets most exciting. And by dance, I mean an acronym for disability, accommodation, necessary, cost, and effect. So when the landlord is deciding whether to serve that notice or not, he or she has to determine whether the tenant has a disability as defined by the fair housing laws.
Okay, excuse me. You're talking about fair housing laws, and the gentleman next to you was talking about a substance abuse or alcohol abuse previously, if that hinders them having housing. And 13 years ago, I had issues with that, and I came to an apartment complex that had fair housing, and because of issues 13 years ago, they did not provide me with housing. You know, and I'm trying to understand. I thought at that time, and I had support from a program that tried to talk to them, and they would not even look at me to get an apartment. And now, you're saying there's a law that's protecting us?
Yes, and the law is both federal and state, and it's still current right now. In other words, it sounds like, and we can't really talk about any one individual's case, that you were a victim of discrimination. If you had a history of alcohol and/or drug addiction, that is a protected disability under the fair housing laws, federal and state.
And then for A, accommodation, is the tenant requesting an accommodation of the housing provider's rules or practices? Is it necessary? In other words, is there a nexus? Is there a connection between the disability and what it is the tenant is wanting? And it's usually about the time that a notice is served, that tenant's attorney then serves a form letter to the landlord saying...
They're carefully crafted, each and every one.
Very, very carefully crafted. Cookie cutter crafted to state that you can't proceed with the eviction because my client is disabled. Those letters generally are a smart thing to send out, but there's not enough time generally that the tenant's attorney has to do evaluation of their client, so it's left blank. Please, don't throw that form letter away just because you think it's incomplete if you're the landlord. Save it, and you must respond to it immediately. And inquire. You must take the next step in this dance and ask, what is the alleged disability, and what does it have to do with all of this noise that the tenant's making at night? And then the dance gets a little peppier, and generally nothing happens, and there's just a lot of stumbling around. Or there's a real letter from a physician saying that my client has a specific disability that's causing this noise at night. Hopefully the letter will say, my client was using the wrong sort of medication, and it's going to take a few more weeks or months, we believe, before regular behavior can resume again. Please accommodate my client during this disruptive period. Most prudent landlords then will spend the time needed and help to get caregivers at sometimes to ensure the quiet enjoyment of the other tenants in the building and to see this rough time through. But if nothing happens, or if the tenant willfully refuses the medication and/or therapy, then the landlord will have a paper trail to show that they've done everything to accommodate, and they should then proceed and serve the notice. And they'd be better able to prove their case in court.
May I ask a quick question?
You bet.
Let me get the mic. Let me someone get the microphone too.
Oh, okay, I'll ask that.
Pardon me? Where's it?
May I ask a question?
Yeah, go ahead.
May I ask a question?
Please.
Maybe just this one and then this one.
I have had the mic for a little bit, so may I ask a question, or?
Go ahead.
I have two questions about liability.
Could you raise your hand, please? I can't see you. Oh, hello, sir.
I have a couple questions about liability. You mentioned that landlords and the tenant can write in-home support service worker or other care provider into the rental agreement. So my first question is, if that care worker becomes injured by the premises or in performing the work, who are the possible parties responsible? And second, I see that there's a request that the tenant disclose their medical condition to the employer or to the landlord. So I'm wondering, what are the HIPAA implications or privacy as to how you prevent that confidential information from getting beyond that one wall or whatever?
On the liability issue, most landlords I know, especially ones with mortgages, have liability insurance to cover them for a slip and fall or injury that the caregiver might have, particularly if they're written into the lease. Regarding the employment issues, I'm not. That's beyond the scope of this MCLE course. So and we're short for time, so I'm going to have to pass on that question unless somebody else wants to take it up.
I don't know what the question is.
It was a HIPAA question.
Yeah.
All right, my question
Yes,
is,
sir.
in regards to reasonable accommodation, you've been speaking about it in the context of a nuisance, but what about in terms of non-payment of rent? Is it ever...
Yeah, non-payment of rent. Normally, when Tom and I, Mr. Drohan and I, Mr. Drohan being the tenant attorney, and I have these sorts
We do
of
the dance all the time.
Yeah, and that's why we know that it often involves more than one. It's more like a square dance. When it's a non-payment of rent case, most of these cases are settled, and we'll go through a stipulated settlement that are often made in court. Usually, tenants go to RADCO or other places where they can get financial help. They seek help from their physicians to stabilize their condition, so to keep their job, and to scatter around, to be alert enough to ask, because we all need help from time to time, to ask for friends or family for help. And if that doesn't quite pan out, Mr. Drohan and I will normally enter into a settlement agreement for what we call an easy payment plan. And that's where the landlord may have to wait a month or two before the plan kicks in. But then the tenant has to comply with monthly payments over 6, 12, sometimes 24 months. And this isn't just a way of the landlord guaranteeing he gets that the rent comes in, but it's also I found over 36 years of doing this, that it helps to discipline the tenants to get into the regular habit of paying the rent on time. If they know that they're under the gun, if they know they can be evicted for breach, they're much more likely to get their rent in on time, and they often get to this point where they pay the rent before the first of the month, and they're no longer a problem. So we've averted an eviction. The tenant learned a habit that we all have to learn and relearn from time to time, and it's win-win when we can successfully get a payment plan. But there are agencies out there to help the tenant get the first down payment, and also counseling to ensure they get on the right track.
Yeah, another more procedural response to that would be CCP 1179 allows a tenant who has lost an eviction case to apply for a motion for relief from forfeiture, and it's specifically effective in non-payment cases. And the motions are granted when the court determines that to evict the tenant would be an extreme hardship. And so theoretically, the facts that give rise to the disability defense would also give rise to a successful motion for relief from forfeiture. So sometimes you tell the landlord attorney, that's what we're going to file if you don't take our settlement offer, or you get it on file and then you settle the case.
And do note that under this law does help landlords get aligned to agree to the payment plan, because they know they can spend $20,000 or $30,000, $50,000 in a case, successfully get a judgment against the tenant for non-payment of rent, and then have it all set aside with a petition for relief of forfeiture. You're next. And can you get it sealed?
The question was, how do you get an eviction case unsealed? Is that what you said? Correct.
I've never asked for one.
I don't know why anybody would want to do that.
Well, they filed the same case I had. They
Okay, there's something I was going to talk about in my.
Okay.
Should I just get?
I think maybe we should just move on, maybe
No,
into Tom.
I'm going to talk about sealing records in mine. So.
And is that okay, Michael? Or we're almost
Oh,
done?
just a moment. I can defer to you, Mr. Drohan.
Well, thank you, Mr. Rossoff.
Okay, so Tom Drohan will talk about eviction protections and this ceiling we're talking about.
Yeah, a lot of what I was planning to address today has already been addressed ably by Mr. Rossoff, and more than ably by Dr. Collins, who I recommend, if anybody's getting evicted in this town, you call her, because she seems to be the best tenant advocate around. But my name is Tom Drohan, and I'm employed at Legal Assistance to the Elderly, which is an agency here in San Francisco, and we provide free legal services to seniors and disabled adults over 18. LAE has been around since the mid-70s, providing free legal services to San Franciscans. And because of the nature of the way things are going on in San Francisco right now, you may imagine that we receive quite a number of eviction cases, and quite a number of eviction cases where disability would be useful as sort of as a defense. And so I want to talk about the nuts and bolts of how eviction cases work, and then get up to the point where we talk about how we use the disability defenses. And I want to talk a little bit about representing senior and disabled clientele. I talk to a lot of other lawyers who have clients who, email them back 5 minutes after they get something, and they do a lot of communication in ways that are very effective for assisting the client in defending their case. But we have clients who sometimes can't get to our office, sometimes can't talk on the phone. We have a lot of monolingual Spanish, Mandarin, Cantonese clients that need interpreters. And so there's some extra struggles for the attorney who's going to be dealing with a client with disabilities to be able to make sure that they can assist that client to the full scope of their ability, and be able to work with the client through their disability, and make sure that they're communicating effectively with the client, and they're making sure that the client understands and is competent sometimes to make their own decisions. We have seniors sometimes who are in the maybe early stages of dementia, and we have to determine whether or not this is somebody that we can even represent. Do they know what's going on, and can they make their own decisions? So those are some issues that can come up. I want to talk about the basic eviction structure. Evictions happen every Wednesday in San Francisco. The sheriffs go out and they get all the really biggest ones, and they go to somebody's house and they open the door and they move the tenants out on the sidewalk. And then the landlord is there with a locksmith who changes the lock, and the tenant is now on the sidewalk and all their stuff is indoors. And it happens as much as 30 or 40 times every week. It happens to seniors. I've had a 95-year-old client thrown out by the sheriff. It happens to plenty of disabled people in this town. And a lot of people think it can't happen because I'm a senior or I'm disabled. And there are some protections and there are some procedural things that maybe delay it, but it does happen. We handle mostly tenant evictions. We get homeowner evictions, homeowners who have had their places foreclosed. A rare event is when we get somebody being evicted from a nursing home, in which case we call the ombudsman's office, if anybody knows who they are, and if that's a situation that you have any familiarity with. But basically what happens is a tenant comes in with a case called an unlawful detainer, because the tenant has been served with a notice terminating their tenancy. That notice has expired, and the landlord is claiming that the tenant is unlawfully detaining in the property, and has given the tenant this special kind of lawsuit that in California means that the tenant has only 5 days to respond to the lawsuit. Every other kind of lawsuit, you get 30 days to respond. In unlawful detainers, eviction lawsuits, the tenant only gets 5 days to respond. And also the trial comes very quickly, sometimes only 20 days after the tenant files their answer. So the time frame is very compressed. It's not these months and months and year-long cases that you hear about. So it's very important that the tenant respond immediately when they get the summons and complaint, which is what starts the lawsuit. I'm also very happy to be connected with another organization here in San Francisco, the Eviction Defense Collaborative. They're at 995 Market Street on the corner of 6th and Market, at least for the next, I don't know how many months, but before they move. It's an organization where when you're served with a summons and complaint, you can take your paperwork in, and they have experts there that know how to write the responses. Because if you don't get your response into court within 5 days, you automatically lose the case. And they can help get the tenant get their response in on time so that the case isn't immediately lost. And they know how to interview tenants and find out where the defenses are and raise those defenses in the answer that gets filed. And then also refer people to other agencies that might be able to represent them full scope. In other words, where the tenant has their own lawyer that goes to court with them. Mostly what the EDC does is give papers for the tenant to take representing themselves, but at least they've got their papers in court and they haven't lost automatically. Now there's three kinds of housing basically in San Francisco. We have the rent control housing that we hear a lot about, and those are rental units primarily that are built before 1979. And those are covered under San Francisco rent control, which controls how much the rent can go up each year, and controls how much, what reasons the landlord can choose to evict a tenant. We also have housing that is subsidized housing through various different state, local, and federal types of subsidies. And generally these housings also have leases that require that the landlord have a just cause, in other words, have a reason to evict. And then more and more, as we see all this building going up around San Francisco, we have brand new housing that is exempt from the rent ordinance and is just going to be covered under California state law. And under California state law, if you're not protected by the rent ordinance or you're not protected by some sort of subsidized tenant rights, the landlord can give you a 30-day notice to move out for no reason at all. If you've been there for more than a year, it has to be a 60-day notice. If you have a lease, he has to wait till the lease is over, but at the end of the lease, he can say, your lease is up, get out. Rent control protects tenants from these types of evictions, but as we're seeing, there's more and more housing in San Francisco that is not rent controlled because it's being built right now. I think the folks from the Department of Fair Employment and Housing went over the different laws. There's the Rehabilitation Act is the federal law that provides rights to disabled. There is the Americans with Disabilities Act. There's the Federal Fair Housing Amendments Act. Those are all federal laws that provide disability rights. There's the the Fair Employment and Housing Act in California, and also the UNRRA Act in California, which incorporates the Americans with Disabilities Act into it. So there's a lot of stuff stacked on the table as far as law that supports the rights of disabled tenants. I just do want to interject, Michael, when a tenant is asking for requesting a reasonable accommodation and sort of a modification to the unit, if the tenant's willing to pay for it themselves, the landlord has to accept it.
I would say so.
Yes. So if it's a prohibitive cost, but the tenant is going to pay for it and then remove it when they leave, such as a Starivator type of thing.
When we say a prohibitive cost, we normally mean that
the landlord's usually made
$50 and the tenant can afford it.
Yeah. Some of the things, for instance, we have a case now where we're going to be putting in an assistive Starivator kind of thing, and there's funding from an agency that'll provide that for the tenant.
I don't know anyone that any landlord would say no to that.
I'll tell you who he is later.
All right.
Yeah.
It's good to know
So
these things.
the first step for the tenant who wants to assert disability as a defense is to write the letter of reasonable accommodation. And so the dance begins. And I would have Dr. Collins write mine if I were you. But we try and write, as somebody brought up, a question about the nexus. It's very important that the letter requesting a reasonable accommodation state clearly what the disability is and why and what the accommodation that is requested, and why the disability and the accommodation requested have some sort of a nexus, and why that makes sense for the landlord to grant it. We recently had a trial last month where the judge threw out the reasonable accommodation letter and said the letter was not reasonable. The reasonable accommodation letter said, "I'm disabled, please talk to me about about dismissing the case." The judge felt that was not a reasonable request, and so struck our disability defense at the trial. It turned out not to be important, and I think it was the wrong decision by the judge, because the federal case law shows that once you make a request for a reasonable, the request doesn't have to be reasonable, you have to make a request for a reasonable accommodation. The landlord then has to come back and the dance, as Michael calls it, the interactive process. The landlord is required to engage in an interactive process. If the tenant says, "I'm disabled, drop the case," the landlord or the landlord's attorney might say, "That's not a reasonable request," but they cannot ignore it. They have to come back and say why they think it's not a reasonable request, or explain why this fits with your disability, or narrow your request. Failure to engage in the interactive process itself, in other words, failing to respond to this letter, is a violation of the Americans with Disabilities Act and the Fair Employment of Housing Act. It is discrimination. And just to back up, the discrimination claim comes because if you are failing to give a disabled person a reasonable accommodation, you're discriminating against them. And discrimination is a defense in unlawful detainer actions in California. So now we've strung it out even a little further, that failure to engage in the interactive process is also discrimination, because it's failure to obey the conscripts of the Americans with Disabilities Act and the Fair Employment and Housing Act. It's very clear from the case law that this is the case. It's not always easy to get judges to do what the law says, and so we don't necessarily always get this point across. It's a subtle point, but it's used better in the negotiation pre-trial than it is during the trial. And when you have intelligent attorneys like Mr. Rossoff on the other side, he advises his clients to engage in the interactive process because he likes the dance. Yes.
That too.
So then we get to the thing, what do you have to give out in the interactive process? And this is another issue that I grapple with in cases, because the landlord's attorney, there are some attorneys who are very inquisitive, and they want to know everything. They want all your financial records. They want all your doctor's records going back 15 years. They want to know where you pick up your prescriptions. If you have a marijuana card for your prescription, how much marijuana do you smoke and where do you buy it? Situations like this starts impinging on the medical privacy of the tenant. So we got to somehow find a balance between the interactive process, because the landlord is required to inquire from the tenant, what can I do? What is your disability, and tell me about it so I can figure out ways to make it so that you can fully enjoy the use of the premises. On the same time, the tenant has their own medical privacy and HIPAA concerns, and just the fact that just because they're disabled, you don't have to spread your whole life out in front of the landlord. There's essentially no settled law on this case. We have a case we argued this morning in the eviction courtroom that we're waiting for a determination from the judge, and whoever loses it, the landlord or the tenant, we're going to end up appealing it. But the one source that I found is it's called a joint statement from the Department of Housing and Urban Development and the Department of Justice. This came out in 2004, and it's trying to clarify what a reasonable accommodation would be. And I'll just read it out loud here. Question: what kinds of information, if any, may a housing provider request from a person with an obvious and known disability who is requesting a reasonable accommodation? Answer: a provider is entitled to obtain information that is necessary to evaluate if a requested reasonable accommodation may be necessary because of a disability. If a person's disability is obvious or otherwise known to the provider, and if the need for the requested accommodation is also readily apparent or known, then the provider may not request any additional information about the requester's disability or the disability-related need for the accommodation. If the requester's disability is known or readily apparent to the provider, but the need for the accommodation is not readily apparent or known, the provider may request only information that is necessary to evaluate the disability-related need for the accommodation. So this isn't the same thing as having as in a case or in a statute, but it's very informative what the Department of Justice and the Department of Housing feel is important. And although a lot of people like to say you don't have to tell them what your disability is, that doesn't always win the argument when you're doing the dance, because you do have to give enough of your disability so that the landlord can understand why the nexus that you're claiming is proper and why the landlord needs to grant that request for reasonable accommodation. When you go to it, there's cases that describe some of the cases that talk about what has been held to be a denial of a reasonable accommodation. In McGarry versus City of Portland, I'm not going to read all the sites here. I don't want to bore everybody. That's why we don't have a visual presentation. We're just lawyers. We don't do anything exciting like visuals and stuff. It's just briefs for us. But Portland versus McGarry, the City of Portland was bringing an action against a homeowner who was a hoarder and had trash in the yard. The homeowner had AIDS and requested more time to clean up, which is basically what we're doing in all of our hoarding cases. The city denied him the time, came and cleaned it up themselves, charged him for the cost of this and put a lien on his house. And he sued the city and won. And the court held that they did not honor his request for a reasonable accommodation. Some other cases that we see in the housing context, the Sugar Mills case was a tenant who was threatening other tenants, other neighbors with violence, hadn't actually done anything, and he was evicted, turned around and sued because he claimed that the landlord did not give him a reasonable accommodation of his mental disability, and that he wasn't going to hurt anybody, and that landlord should have taken some steps. And the court agreed and upheld that the landlord had not made a reasonable accommodation for the tenant in that case. Another case going even further, in another Colorado case, Roe versus Housing Authority of the City of Boulder. In that case, the tenant was actually punching other neighbors in the hallways of the building where they all lived, and requested a reasonable accommodation of his mental disability. And the court held that the landlord could not go ahead and evict without going back to the tenant and to see what, if any, reasonable accommodation might be made. So these are pretty strong cases for the fact that the courts should look at the duty to provide a reasonable accommodation very severely. Radecki versus Jora was one where the tenant told the landlords that he was ill and needed more time to prepare for a pest inspection. The landlord denied that, and the tenant asserted that she suffered from severe depression and needed more time, and the court held that the landlord had a duty to grant that request also. So those are some of the contexts that they're similar to other things that we've seen. Also, somebody asked about something where I think there was a question earlier that they hadn't gotten a response on their request for reasonable accommodation. A delayed request is the same thing as a no. And there's case law on that effect. Also, as Michael pointed out, you can ask for this request for reasonable accommodation at any time, even up to and including the day of eviction. And there's still a duty of the landlord to offer that reasonable accommodation when requested. Our advice is don't wait that long.
But sometimes a health condition arises at the last minute, and the tenant needs more time.
Yeah, I mean, we have cases because the sheriff actually refers us people who have only because they're bedbound, didn't realize that there was this summons on the door and a notice from the sheriff on the door. And it wasn't until the sheriff knocked and explained to the tenant what was going on that they realized they were being evicted. And that goes back to when I talked about you only have 5 days to get your paperwork in. Once you're served, you've got to go to the Eviction Defense Collaborative that day or the very next day, so they have time to prepare your response. And that's going to help you fight your case and get your reasonable accommodation. It's very difficult to fight these cases when you've already lost and you've got a judgment against you, and there's a sheriff notice, and he's coming next Wednesday, and you want to make sure that you get your papers in on time.
And in which case, if that's happening to you or anyone you know, go to EDC. They'll be in there Tuesday morning to get a stay of the eviction that would otherwise be happening the following day. Then they can make a motion to set aside the judgment and give you a fresh start on defending that lawsuit.
So a couple of, yes.
Oh, okay, thank you. How much time is granted to the landlord? Let's say I put in a request for reasonable accommodation. 5 months later, no answer yet. What is the guideline?
Well, I don't think there's any specific guidelines, but if you've gone to trial and the landlord hasn't come back to you with a response, obviously it's too long. 6 months was in this case too long. I would think if you're in the middle of litigation, unlawful detainer litigation, where everything turns around on 5 days' notice, 5 days would be held to be reasonable. At that point, it would be incumbent upon the landlord to respond. Otherwise, you would be raising at trial, Judge, he never responded to my request. Lack of a response is a no. It's a denial of my request. So at this point, he's on record as denying my request. So it really behooves the landlord, and landlord's counsel probably tells them this, to get back in a timely manner.
But each case is different. If the tenant had given 5 bogus requests for accommodation in the past, and at trial or during trial he lays out another one, then the landlord would be able to explain to a jury, I didn't respond because there would have been no point to it. And then the jury could decide whether the request was reasonable or not. But generally, the laws that Mr. Drohan is stating apply. There are circumstances where a landlord might win, but I wouldn't chance it. I would advise the landlord to give another response in the same manner as before and not take the chance.
Thank you. Thank you.
Just a few more instances. Some of these have been discussed. Waiving the no pets rule because somebody needs a service animal. Clearly a request for reasonable accommodation. In the hoarding cases, as many as 8 to 10% of seniors suffer from the hoarding disorder, and we used to have to fight these cases pretty hard with the other side. But these days, now most landlords and landlord's attorney are aware of this as a disability, consider it a disability, and offer extra time to clean out. Sometimes the hoarding client wants to say, well, as a reasonable accommodation of my disability, can I just keep all the stuff? And the answer is no, you can't. But you do get more time to clean out. And we've had 6 months stipulations where every month we go in for an inspection, and the first month is the hallway, and the second month is the bathroom, and the third month is the bedroom. And there's been some very reasonable accommodations made by landlords on these cases.
And in those cases, the landlord gets in most trouble with the city, who doesn't want to get involved with the eviction. They just want the job done. So the landlord can often be in quite a scare dance with other governmental agencies. And we hope at that time that the Tenants Council can help out. And sometimes they do. Some attorneys will actually go out to their clients' apartments and help clean themselves.
I have a question.
Yes.
I have a question.
Yes. Perhaps if you be precious also, and you don't have time to clean up because of pressure and harassment, and you have to move immediately, then they don't give you no time to clean up, and they turn around and say they don't want to give you the deposit that you, when you before want to live in that place, you give the deposit first, and then they deny to giving you the deposit. Would they have the right to keep the deposit?
The landlord can be in trouble if the landlord didn't give a comply with Civil Code Section 1950.5 that states that the landlord and the tenant should walk through the apartment several weeks before the move-out date. And if they fail to do that and the landlord does not inventory the work that needs to be done to get the premises back to the way it was at the time it was rented, minus wear and tear, you would have a good argument to collect your deposit, plus the interest that's available to you under Administrative Code Section 49. It's a tough argument in small claims court to state that you knew you were being evicted, for example, and didn't have the time to clean up. But each case is different. But I would certainly start with the law, start with your rights under 1950.5, because most landlords facing eviction don't bother to give notice, and that can give an edge to you as a tenant.
I never got an eviction in the first place because I always pay the rent on time. The case is they wanted to get somebody in so they can rent the room for more cost.
Yeah, I would go to small claims court and you probably get your deposit back.
Okay,
yeah, they do a lot of those cases in small claims court. That's the best venue for that. Yeah.
Thank you.
There's another question, real quickly. This person has been waiting for a while.
Okay.
I don't know if you care to comment on stipulated judgments, the difference between with prejudice and without prejudice, because I understand that does have implication for later if you rent, for example, public housing. And also in the case of constructive evictions, whether that matters or not, if you care to comment, I don't know if it's related to.
Well, those are pretty separate things. I'll talk about prejudice and with prejudice and without prejudice. Generally, it's going to get to the point where we talk, before you go to trial, you have a settlement conference, and 98% of all these cases settle usually at the settlement conferences, and we don't go to trial on that many. Trial is risky, and if you lose, you're out pretty quick. Settlement conferences, hopefully we get a settlement where the reasonable accommodation is granted and the tenant is going to stay. Worst case scenario, the tenant has to move out as part of the settlement, but we get more time for them to move out, or some relocation money, or both gets paid when they move out. Part of what the settlement conference usually does, the settlement calls for the record to be sealed. And as somebody was talking earlier, these court records are available online, but you can ask the judge to seal your records in an unlawful detainer case. It's actually not the same, it's not really sealing them, it's called masking. So the records are still there. They're available to anybody that goes to the courthouse and knows the case number and the address and the names of the people involved. So you have to be sort of intimate with the case to be able to look at the record, but it's masked on the internet. Sealing records that somebody else brought up is another process that goes on in other types of cases and wouldn't really apply in the unlawful detainer. But also what happens as part of the settlement is the parties agree that the case will be dismissed. And the dismissal form that everybody uses and checks the boxes off says a box with prejudice or without prejudice. If you're dismissing something with prejudice, it means you can't bring that case back up again. If you're dismissing something without prejudice, for instance, our office does a lot of cases where we represent debtors who are being sued for credit cards. And the credit card companies usually back down when we show up on the day of trial, and they dismiss the case. But they dismiss the case without prejudice, meaning we reserve the right to come back and sue you on this debt again. In the eviction context, it really doesn't matter if something is with prejudice or without prejudice, because it'd be very difficult for the landlord to come back and sue on the exact same notice. So, and it also would have no bearing on your record in terms of somebody looking at if your case was dismissed with prejudice or without prejudice, in terms of looking you over for subsidized housing later. So that was, I basically wanted to touch on the settlements. That's a procedure. It takes place at court the week before trial. You go there. There's a great program run by the Bay Area, the San Francisco Bar Association, and they'll provide you with a lawyer for the day that's called a limited scope attorney who will be there with you for your settlement conference. So you'll have somebody who knows what they're doing to help guide you through the settlement process. And ideally, you get your case settled, your reasonable accommodation is accepted, and you remain in your home with a better educated landlord. And if you don't get that done and you're going to trial on Monday, give us a call. Yes. Thank you.
Okay.
So now we've got a couple of people who are going to talk, who are tenants or relatives of tenants, who are going to talk about their experience. First, we have Alan Zeltzer. Do you want to go ahead?
Oh, hi. My name is Alan Zeltzer, and I'm a tenant in a co-op here in San Francisco. I've been in first of all, I should let you know I suffer from, I had a blunt head injury and violence, and so I suffer from PTSD as well as seizure disorder, and even prior to that I had Crohn's disease. So I'm more disabled than I appear, but that's what led me into public housing. As a result of the violence, I ended up in a psychiatric facility, and through that, in San Francisco, they have housing programs which are run by co-ops, which they can basically, after you go to a treatment facility for a while, which you can also use that housing facility, which is basically these programs which are run by basically three nonprofits in San Francisco. And I've been in public housing or this type of housing since 2006, or 2009, excuse me. And what's important, one of the things important reason why I'm here is, first of all, I'd like to call, just myself, I would like to say that there has to be massive public housing expenditure for disabled people in this country. And also, there must be massive public funding for disabilities in this country, particularly mental disabilities, because we can see the problem of uncared, untreated disabilities, especially psychiatric disabilities, manifesting sometimes in a very, very serious way, hurting other people in the community. So, I mean, the only way around this kind of situation is to provide more funds for these programs, and that's something I'd like to just point out. In this housing in particular, I have experienced 2 incidents of serious violence from other tenants, and in the first instance, I went to the court along with a roommate and sought a temporary restraining order, and then got an order. And then in the last incident, there was an individual living there who was violent and as well as using drugs, who, after long discussions with the co-op, they eventually committed violence, and then I needed help from the victims program in San Francisco in order to proceed, basically, with living. In these 2 incidents, I actually, basically, my roommates and myself had to act on our own. I mean, the problem in what I'm looking at in terms of this type of housing is that you have caseworkers that are assigned to this housing program into the housing units. But these caseworkers have only limited power. I mean, they don't really have in terms of the way this housing is run, the power really is with the property management in these units, and I think this is a very problematic, because I think people living in the housing see situations, they bring it to the awareness of the people in the program, the caseworkers, and then the caseworkers can only go so far in acting upon it, unless it's extreme seriousness, a serious violent incident where the police are involved and things like that, and then they can act. I think this is not well, in my situation, what happened in the first 2 incidents, these 2 roommates were removed who were problematic. And in the current situation I live in, we had a roommate that moved in 3 years ago who began stealing from us and the other roommates, as well as being physically confrontational. During this time, we sought help from the co-op, and really, because of the way the co-op is set up and the caseworker has only so much power, they can only make suggestions, basically. They really can't do too much to really take care of the problem, I believe. So the main thing that I've seen happen in my situation and with other people is many times, like in the person that was prior to the person that the current situation, the person was allowed to move on into housing again and did the same thing. So, I mean, in looking at these situations, what happened in the current situation, even though we attempted to deal with the caseworker, with this person who was stealing from us and being violent, and also as well as using drugs in the house, there was no. In my particular case, I think I'm looked at as a whistleblower because I've raised these issues. I've gone above and beyond the co-op itself to the state court in order to get help. And I think that it's problematic with the people that run the co-op because they feel you're going above them basically.
Excuse me, Alan, 1 second. I'm sorry. I think the technicians here are saying we have to leave, so I think I'm going to ask each. We have several remaining speakers. Maybe everybody just have a few minutes. Is that okay?
So mainly, the main thing I only had 5 minutes anyway, but the main thing I think is important is that the county be given much more oversight on these nonprofits. And that basically they have to, like my caseworker and other caseworkers are well aware of some of these problems as they develop and have really no say.
Have you spoken to Bevan Duffy about this issue?
No, I haven't.
I recommend that he works for the mayor's office or for City Hall, and he'd be the best person to key into.
Because I think oversight is really important.
Specifically regarding
I think
your
that
co-op.
the caseworkers that work for the county have a really good, idea of what's happening in many of these houses where they're working with, and they can assist. And actually, if they had oversight,
Mr. Duffy used to be a supervisor here. He's keyed in. I think he can be of great help to you.
Okay. So maybe you can talk afterwards about some suggestions.
So basically, I mean, I think these programs are very, very important. I think they're very helpful to the disabled community, but I think there has to be oversight and there has to be more funding.
Okay, thank you.
That's.
Thank you. And then we have Aisha Scott, and so I know it's hard to reach the microphone here. Yeah. Is that
Hello. So since we don't have a lot of time, I was going to talk to you about how I obtained housing and what challenges I had with my disabilities and how to maintain it. So basically, what I'd like to say is I actually have programs. There are nonprofit organizations that are out there to help you. I happen to be one of the lucky ones, and I went to a program called Bonita House, and it helped me to get my challenges and my disabilities stabilized. And once I got stabilized, they helped me to get into boarding cares, where I was able to get on housing lists, where I could get subsidized housing. This housing was 30% of your income. I went through a program called East Bay Community Recovery Project, and they actually paid the majority of my rent, and I paid 30% of my income. But eventually I graduated, and the apartment that I was in, I had paid the deposit, and the landlord did not want to give me back my money. He had me sign papers saying that I had an inspection before I left, which he didn't, and he was trying to charge me not only to keep my deposit, but funds $200 and something over, and I didn't have the money, so I was very worried. But what I did was I went to legal aid, and I got someone to write up paperwork, and they helped me write a letter and send it to him. And even though he was still trying to charge me, she showed him that there were things that were not legal that he did, and I was able to keep my deposit. Right now, I have learned, because it's hard to keep housing when when you have a disability, I've learned that I had to set up like what I call a wrap plan in case I'm hospitalized. And this plan, it just helps you to actually put in place people that will pay your rent, people that have access to your checking account, people that if you're hospitalized, they can take care of your pets, people that can come pick you up, people that when you go home, they can sit with you for a couple of days. Whatever it is that you need, they provide them for you. Right now, I'm pretty stabilized, and I do have very good housing. I was able to get a subsidy of $634 a month, so that does help, especially since I'm on SSI. For me, the main thing that keeps me stable is being able to do things in the community. And I'm actually going to college, and I got places like the Department of Rehabilitation to help me pay some of my bills. They pay for me to go to school. They pay for my internet, you know, and it's just different things in the community. There's something everywhere. There are community resources everywhere that will help you. And sometimes I learned these resources through word of mouth. I didn't know about a lot of this stuff, but I get out into the community. You know, I get on the bus. I'm in a program. I talk to a case manager, and they let me know what type of resources are out there. You know, and we just have to, I had to learn to look for resources. I learned because the program discharged me. And what was I supposed to do after they discharged me? I needed help with furniture, household supplies. I had none of that. Okay, I had none of that, but I had to learn to get that and obtain it. Thank you.
Thank you. Lisa Noriega is going to share her family's experience with advocating for the therapeutic animals.
Hello, my name is Lisa Noriega. I work for Contra Costa County Behavioral Health Services, Office for Consumer Empowerment. Today, I'm going to share the story of me and my mother advocating for her therapeutic animals. So this is my mother. My mother's name is Gail. She was too shy to come today, but she was eager for me to share her story. In 2008, my mother suffered a traumatic brain injury when she accidentally slipped off a curb. My mother has physical, emotional, and cognitive function impairment because of it. She gets permanent vertigo. When she looks up or down, she falls down. She gets really dizzy. Another physical impairment of it was Meniere's disease. She has water on the ear. And with her high blood pressure, when the water on the ear begins to thump, she starts to panic. She's developed anxiety, panic attacks, and depression due to the TBI. She lost cognitive functions, such as she's impulsive now. She'll spend all of her money and then not realize that she still has bills to pay. Or she'll start cooking dinner and walk away and forget, and it starts burning, and she panics. Because of her loss of linear thought patterns, my family and I sat down with her and discussed the idea of possibly relinquishing power of attorney. After some discussion, my mother agreed. My mother is not conserved. She handed it over willingly. So let's talk about the first therapeutic animal we had. This is Yoda. Yoda is deemed a therapeutic animal because he helps with my mother's actual physical impairments. When my mother is high blood pressure, she pets the cat and it lowers her blood pressure. It combats loneliness, and it provides a sense of calm. Also, when my mother cooks, he jumps up on the counter and reminds her that she's cooking. So the first incident with the landlord, there were new rules set in place that had nothing to do with my mother's animal. It had everything to do with people living in small apartments with large breeds. But it had to be full scope across the whole board. So we discussed with the landlord the fact that my mother needed her cat. They kept threatening eviction. They left multiple letters on the door, even though we had already told them this is a therapeutic animal. We did not have a note to provide at the moment, though. So there were a lot of surprise inspections, which led to my mother's emotional outbursts and bouts of depression. My mother would wander around the house and have anxiety and panic attacks because she would look around thinking, do I keep my house or do I keep my cat? And this went on and on and on until we were able to get to the doctor. I was able to put the landlord off long enough so that we never actually got a 30-day notice. So these are some of the legal steps we took. Okay, so luckily I work for mental health. So I researched the MHSA, that's the Mental Health Services Act, about therapeutic animals, what constitutes it, where do I need to get the note from, and the landlord continued leaving 3-day notices on the door. I assured my mother that I was going to take care of it. We went to my mom's primary care doctor and had a discussion about what could we do. The doctor was very understanding and immediately wrote us a note. So initially, the landlord rejected the note, saying my mother was not mentally ill, my mother was physically disabled. So I printed out the MHSA Act and explained that because my mother has bouts of emotional outbursts, she does take medication for anxiety and depression, she does indeed fall under this Service Act. So the note was accepted. At this point, I had an in-depth conversation with the landlord regarding my mother's condition, the fact that I was her power of attorney, and that all the communications regarding concerns should be directed through me, as they confuse and upset my mother, and this affects her well-being. Considering my mother's high blood pressure condition and the fact that the panic attacks can make her blood pressure go even higher, my mother is at a potential risk for stroke. So upsetting my mother could kill my mother, and then I will sue you and own your apartment building. So this was the secondary animal. This one is her companion animal. This is Baby. Baby is listed and registered as a companion animal, which is very different from a therapeutic animal. A companion animal goes everywhere my mother goes. It assists with anxiety in public settings and driving. It promotes her wellness through the playfulness of the animal, and it gives my mother something to focus all of her anxiety on. When she's out in public, she's got to take care of this dog. She's got to be strong for the dog. So it helps her. It overall improves her quality of life. The dog is really yappy and annoying, and my mother loves it to death. To death. She loves it to death. I wish I could have got a picture of it in its little sweater. So we had another incident with the landlord. So the landlord did contact me this time, though. Good landlord. And threatened eviction. I researched laws again because I knew that there were differences between therapeutic animals that are for physical ailments and things that were for actual anxiety. So the landlord came back and said that my mother already had an animal so that he didn't have to meet her reasonable accommodation. So we went back to the primary care doctor, good old Dr. Bird, and we explained what was going on, and Dr. Bird, in his infinite wisdom and compassion, wrote a very, very detailed note describing the differences between Yoda and Baby, and the need that my mother needed for my mother not to isolate and for her quality of life to continue in a semi-independent state. She needed an animal that could go everywhere with her. But she also needed her other animal to keep her blood pressure low and to remind her, hey, your food is burning. So we went back to the landlord, and I provided the landlord with the differences between a therapeutic animal and a companion animal, and the second note was begrudgingly accepted. So in conclusion, advocating for my mother not only saved her housing, I helped educate a landlord on the differences and the things that you can and cannot do when it comes to somebody. Just because you think you know what the impairment is, you're not allowed to make a judgment on that. It's not allowed. It's not legal and it's not fair. Because of everything I walked my mother through, she advocated for about 4 or 5 other disabled tenants, and they got to keep their animals as well. I know, right? And it allowed my mother to keep a beneficial quality of a semi-independent life. My mother lives on her own with her 2 animals, and it makes her feel like even though she gave up her power of attorney, she's still an independent person, and that was really important to making sure that my mother was okay with the way her life has to be at this point. And most importantly, it reaffirmed the trust between my mother and I. My mother no longer questions what I'm doing, how I'm doing it, or why I'm doing it. Everything I do is in my mother's best interest. Thank you.